did do it, the only way to undo it is either by another agreement or by a motion to set it aside. So now, when you file the motion to set aside, when you've agreed to it, because normally if you've agreed to it, it's usually either in a high conflict custody case or in a resolved divorce case, you put it into a settlement agreement. So when you file the motion, you have to show a material and substantial change of circumstances that warrants a review and change of the custody agreement. And that's going to be the case, first of all, in all these four examples that I'm talking about, but also any custody application you're going to make to change. The standard is always a material and substantial change in circumstances. Here, and the material change in circumstances has to be something that is in the child's best interest. So when you're trying to argue there's been a change of circumstances, part of what you need to do in this first example is explain why you agreed to it, the circumstances that existed at the time you agreed to it, and what has changed substantially that warrants the court reviewing and modifying the agreement. Absent that, they're going to let you stick to it. Even though you agree to it, it's not simply just, well, I changed my mind and I want to agree to something else. You agreed to it, now you have to change it under the legal standards to change any kind of a court order for custody. The second option where sole custody can arise is if there was an application, whether it was a custody application or a default divorce, and you didn't show up or answer the paperwork, and the court entered it in your absence. That's more common than most. Now, that doesn't mean that it's any easier to overturn, because first, the courts may not have granted it unless it was warranted. They usually would review the papers, and just because you didn't appear doesn't mean they're going to grant something like that. But more often than not, they would, absent some response. So in order to change this instance, if you fail to respond, first, you can always do it by agreement also, with a consent order. Or you have to file a motion, again, to change, or setting aside that there's a change of circumstances that are in the child's best interest. Now, in that, you have to, again, explain the circumstances as to why you didn't respond in the first place, give a very good reason why you waited before filing this application, unless it's immediately after the order was entered, and what new circumstances arose that warrant the review of custody. They're independent, but I don't think you can do it without all of those pieces. The court's going to want to know why you ignored it if it's so important. They're going to want to know why you waited if it's so important, and they're going to want to know what's changed since then that means they should review it. The third is when the court has entered it after some kind of a hearing. Now, usually that's going to be one that you participated in because it would only result from a custody hearing, a divorce hearing, or a restraining order, but I'm going to talk about that as my last example. The third order is when there's been some kind of hearing and the court has entered it. It could be a motion, rarely would it be, but it's possible. It's more likely going to be after what's called a plenary hearing, which in New Jersey is a full but a short or simple hearing. If the order was entered after a plenary hearing, you can either seek to reconsider that order if you're within 20 days of the decision. You can file an appeal of the order if it's within 45 days of the decision. If it's beyond that, then again, we go back to the same options. You could get an agreement from the other parent to modify the custody order, or you could file a motion to explain the change in circumstances that go to the child's best interest. The standard is going to be a little higher in this case than the first two examples, because if the court is the one who entered the sole custody order, they had to find that it was warranted. And like I said in the very beginning, rarely is it warranted in New Jersey. So the court had to have had substantial reason to think this was in the child or children's best interest. So your change of circumstances may need to be more significant than in the other two instances. The last instance is the entry of a final restraining order. The reason I put this separately from a court order is because a final restraining order can carry sole custody decisions in two ways. First, the court could actually write that the victim that receives the order gets sole custody, or they could ignore it but leave it silent, because a restraining order carries a presumption in New Jersey of the victim receiving sole custody, because it's presumed that you're not going to be able to negotiate and to handle these issues without the communication. So whether it says it or not, it could still be construed. Here, again, you could try the agreement, but that's very challenging because you likely can't have any contact with the victim because of the restraining order. You'd have to go through the court for service of process, and it's unlikely you get an agreement that the court would also uphold because of the potential of coercion. So again, you'd have to file a motion. Here, you'd have to file a motion to vacate the restraining order. So I guess you could probably file a motion to modify the custody order even if you weren't seeking to dissolve the restraining order. But let me just cover both anyway. Under the restraining order, there's a case called Carfugno. I forget. I think it's Carfugno versus Carfugno, Carfugno. New Jersey sets forth a criteria. I think there's 12 different criteria that you need to specify or satisfy and present to the court to ask the court to dissolve a final restraining order. If you meet those criteria and the court feels it's warranted, the court will dismiss the final restraining order. If the order did have a sole custody designation, it's eliminated. And even if they were arguing in some other hearing that the order gave them the presumption of sole custody, that too is eliminated once the restraining order is dissolved. So I hope that helps to those limited few that actually have sole custody. I know it's strange because most people are asking for just the opposite, to get sole custody from joint, but I did have a client who came in this week, potential client who had agreed to sole custody in his divorce, and it made me think there might be other people out there that could use this help. So hopefully there are, and hopefully this helps. If it does, please give the video a like and share it. I just learned how to answer my comments. I used to think I had to do it on my phone. I couldn't always get to everyone properly, but I now know how to do it, so you can leave me comments, good, bad, or indifferent. You can ask me for future tips if you would like, the same way, or just email me or contact me from whatever platform you're watching. So with that, I'm going to sign off. Wish everybody a great weekend, and I will see you on Monday because I do work on Columbus Day. So have a great weekend.